Hello, everybody. My name is Brandon Scott Avery. This is Forensics 546 with Dr. O'Hara. This is going to be a lesson on competence to refuse an insanity defense. I appreciate you guys during the course of this instruction, and I'll continue on. All right. So again, that's should the courts be able to determine if a person is mentally fit to stand trial, and should a person's rights be overruled if the court determines that he or she is mentally unfit. So we'll continue on. In the next slide, we'll be doing our learning objectives. So the learning objectives for this particular assignment are going to be the origins of parens patriae. Excuse me if I'm mispronouncing that. Then we're going to look at the Godinez versus Moran case, a doctor's assessment, the defense's assessment from their particular side, and then the plaintiffs as well. Competence to refuse an insanity defense. Then we'll look at the Whalen versus the United States and Frendak versus the United States. And then we'll also go over reasons for a person to refuse an insanity plea. And then we'll conclude, and then there's a link to a video at the end. So the origins of parens patriae, again, I don't know if I'm pronouncing that correctly, but if I am mispronouncing it, you can go ahead and leave it in the comment section and perhaps give me an idea of how it's supposed to be pronounced. The meaning directly translates, as far as the assignment, the book is concerned, it translates directly to state as parents. Or the states will be acting as your legal authority, and that's on page 161. Now, I was able to go online and find other resources that said state as a father or government as a father, different variations, but they all mean basically the same thing. It means the state is assigned as your legal authority and acts on your behalf. In the mid-19th century, our society, our Western societies, began to want individual autonomy. Basically, they wanted the individual rights to choose how their cases were going to proceed. And this gives them the freedom to make life-changing decisions, and however they deem necessary. And if they're deemed incapable by the courts will take over. And they also should have the right to represent oneself, and that's where the Sixth Amendment of the Constitution derives from. Moving forward, we're looking at the Godinez versus Moran case. This case is very important. It's separated by 9 days. There were two separate incidents that happened 9 days apart. The first incident, I believe, if I'm correct, he went on a shooting spree and killed multiple people in an establishment, and then 9 days later went on to kill his estranged ex-wife. So, and then the question was Mr. Moran capable of standing trial after that? He offered a confession to the police when he was in the hospital, already in custody. Even after getting multiple Miranda warnings, he continued on with his confession. So we look at things of that nature to determine whether or not he was culpable at the time, not only at the time of the murders, but at the time of his confession. So after offering a confession, the court, the judge assigned 2 separate psychiatrists who both determined that Mr. Moran was in fact capable of standing trial. But then there's also things such as Mr. Moran's attempted suicide. So the perspective of the psychiatrists is something that we have to also take into consideration. Under what authority or under what guidelines are they using in order to determine one's culpability? Mr. Moran was also taking prescribed medication. Ultimately, what ended up happening was Mr. Moran was deemed by the courts to be competent enough to stand trial. He decided to represent himself. He pled guilty and was given, I believe, given the death penalty. So the question remains, was Mr. Moran actually culpable at the time? Now, it was determined that Mr. Moran was schizophrenic. However, his schizophrenia was not a direct attribution to the crimes that he committed. So he knew full well at the time, is what the psychiatrists determined, that he knew full well at the time what he was doing. So let's continue so that we can get to. Simply being oriented to time and place is one thing, but understanding the consequences of your actions also is important. And so what they're looking at and what the psychiatrists are looking for is the person understanding right from wrong. And if they understand that what they did was wrong, then that's, I believe, the baseline determination to figuring out whether a person is fit to stand trial and did understand what he or she did at the time of that the crime was committed. Moving forward, we look at competence to refuse an insanity defense. In Mr. Moran's case, he did refuse, or he made attempts to refuse. The court had assigned a psychiatrist to determine whether or not he was competent enough to stand trial. It was determined by those psychiatrists that he was. What determines if a person is capable of giving their own defense or testimony? A judge can elect to have a defendant evaluated. Sometimes they may do it arbitrarily just because a defendant may be displaying signs of incapability of standing trial or defending themselves. They may give signs that they are probably not, within their complete faculties or wherewithal. If a licensed therapist determines that the defendant is or isn't capable of standing trial, the court will then make its ruling. So it's sort of irrelevant what the individual or the defendant wants. At that point, the court has to make the decision based off of what the psychiatrist's evaluation is. And this sort of takes away the individual freedoms of the person, but we also must understand that there's victims involved in this matter. So when a person's actions affect another individual outside of their own person, that's when the law can now step in, and your individual rights are then put into question whether or not you can still maintain some of them, to include, rights to carry firearms and so on and so forth. Defendants have the right to refuse, but must comply with the courts when overruled, and that was already discussed just a moment ago. So Mr. Whalum was admitted prior to a mental health clinic. And so the courts do look at these types of patterns in individuals' behavior. But what it all ultimately boils down to is not whether a person has mental health issues, but whether or not the person had a mental health issue at the time that the crime was committed, and whether or not that mental health issue currently is affecting them and causing them to not be able to stand trial. Now, this case resulted in a district court code 24-301 alpha, and it makes it a requirement to hold a district court hearing following a mental health assessment. And that's by either the court or the defense. So when a defendant is evaluated, it is now law that they have to hold a hearing and determine your fitness to stand trial. And this is so that they don't convict a morally blameless person. So all of this is an effort to, reduce our inefficiencies as a civilized society. So we'll go to the next slide. Now, this slide discusses some of the reasons that are given for a person to refuse an insanity plea. One may think, why would somebody? But when we go over these next few things, you may find it to be sort of understandable why an individual or defendant may want to refuse an insanity plea. As a judge in the Friend Act court concluded, an individual has the right to make a decision on the course of the proceedings of their case. One of the reasons, or number one reason that was given from that court, was that confinement may be longer than an actual conviction. Sometimes if a person's in for manslaughter or a lesser charge, not first degree murder, but they have killed somebody, maybe it was by accident or something like that, then a manslaughter charge in some states carries a lot lesser of a sentence. Sometimes it's even as low as 5 to 10 years. So, and then you can get out even early on good behavior and other types of programs that they have if you go to school and the prisons and whatnot. So defendants look at stuff like that. If they know that they've committed the crime, they know there's no way of getting out of it, and their best course of action is to just confess and do a plea deal, then that they can get a lesser charge. Defendants may believe better treatment can be found in a prison rather than a mental hospital. And sometimes that's actually true, depending on the state you live in. I wouldn't say that probably for California, but I'm not sure about other states. So that's another reason. But that's also an important thing to look at. A defendant may believe that their treatment could be better. They may have better resources in a prison than they do in a mental hospital. They have better access to people, their family, people visiting them, sending packages. So those are all things that they consider as well. May want to avoid stigma that's associated with mental disorders. Now, this is a bigger thing in some societies that sort of have like cultural societies that are more closely related together, maybe Islamic societies or so on and so forth, where mental health is sort of frowned upon and they don't really like to discuss it openly, in public or whatnot. So it's something that they definitely want to avoid having the stigma behind. And just anybody in general doesn't want to be deemed as a person who doesn't have their total faculties. And then, of course, you have the loss of some legal rights. You can't carry a firearm. You can't go in certain areas. Maybe you're banned from certain programs. So you can't join certain organizations. So there's a lot to consider when it comes to if you're going to take an insanity plea. It's mainly reserved for those people who are in desperate situations and who actually need it, who actually are insane. So it's important for defendants to be careful when accepting a plea agreement like that. I think it's probably reserved for the most extreme situations. And then the defendant may consider their crime a political act. So that essentially negates their entire defense. And that was also in Melton on page 176. All these resources are going to be linked on a slide at the end of this lecture. So I thank you for continuing to join me. Now, this is the conclusion. Should courts be able to determine if a person is mentally fit to stand trial? And should a person's rights be overruled if the court determines that he or she is mentally unfit? It should be noted that all humans have a certain fundamental right granted from birth, and the United States government is responsible for upholding and defending those rights. However, in matters regarding the law which affect the population, now this is people who get affected by whatever your actions are, the courts must intervene and determine the fate of the individual. In rare cases, there are people and defendants who are not aware and fully capable of making rational decisions, which sometimes result in breaking of the law. In these circumstances, I agree that the courts should make a sound determination on whether someone is competent or not to stand trial. And that's because their actions have affected a party that is not them directly. If they're affecting themselves, then I do believe that the law does not need to intervene. But if they affect the population, then of course, and if the individual displays signs that they are not capable of defending themselves in court and not understanding the crime that they committed, then in fact I do believe that they should be given separate separate treatment. So again, I thank you. This slide right here, I'll put the link of the video also in the uh, Dropbox and link it anywhere else I need to, so you guys will have that URL. You could just highlight and paste if you want to watch it. It's just a 2-minute and 30-second video by inside edition of a young man who stabbed a couple to death and then proceeded to gnaw on the gentleman's face. And he was also found not guilty by reasons of insanity. So it's just a quick little video. And then here's the reference page if anybody wants to find out where some of those resources are, as you see. And I again thank you for attending this lecture. Again, my name is Brandon Avery, and I hope that you all have a good understanding now of the course material and enjoy the rest of your day.